Good morning and welcome. Our first case today is Gessner versus Southern Company, number 2024-1835. Ready?
All right, may it please the court? At this time, I'd like to reserve 5 minutes for rebuttal, if possible.
I can't hear you. Mic closer to you a little bit, maybe.
Normally, I don't have that problem. No one's ever told me I'm too quiet before. All right, so may it please the court, my name is Ashley Richardson, and I'm here on behalf of Mr. Gessner, and I would like to reserve 5 minutes of my time for rebuttal. On the surface, it looks like we are here once again to have a lively public debate about the definition of the word is, rehashing the 90s, as it were. If we dig a little bit deeper, the issue is a bit more complex than that, and it stems from the provision within the Florida Private Sector Whistleblowers Act, a very narrow provision that offers protection, and this is 448-102 sub 3, offers protection to employees who object to or refuse to participate in any activity, policy, or practice of the employer which is in violation of a law, rule, or regulation. The is the issue here. My colleagues across the aisle, as well as the first, second, and now fifth DCAs, want that to be interpreted as literally as possible. That is means an employee, to preserve their claim and prevail in court, must show that the employer engaged in an actual violation of law.
Can we focus on the must show part? As a pleading matter, it's true at the sort of, if we just sort of take that statement over the life of a lawsuit, at the motion to dismiss phase, you may be right that the allegation, like any other allegation a plaintiff must make, has to be colorable, has to, there has to be a basis in fact for the allegation. At the conclusion of the matter, when submitting the question to a jury, is it your position that the preponderance of the evidence is the applicable sort of standard of what Mr. Gessner would have to prove to a jury in order to succeed?
Right, so that is one of the issues that we have with this actual violation standard, is that it drastically increases the burden of proof in what would otherwise be a remedial statute. Well,
but that's, I just want to establish first that we agree that in order to prevail and get a jury verdict, Mr. Gessner would have to prove by a preponderance of the evidence that there was a violation of the law. Are we on the same page so far?
Yes. Okay,
well then my question is, what is it that he must prove by a preponderance of the evidence?
So that is
that the violation, that the facts are as he alleged, in your view, or that in fact there was an adjudication or a violation of the law that has been established? What is his burden at trial?
I would argue it's the former, because if we're looking to the latter, where there actually has to be some sort of adjudication or maybe a administrative action, something like that, that's way beyond the scope of what the actual text of the statute says. And also, again, we're looking at a remedial statute that is designed to protect an employee.
Say we take the remedial statute sort of policy debate out of the discussion at the moment, and we focus just on what the original public meaning of the statute is. I just want to make sure that I understand what you're saying Mr. Gessner would have to prove in order to prevail.
I would say that going to an actual adjudication of some kind of wrongdoing on the part of the employer is several steps too far.
So we know that's not it, but what is enough?
I would say that so if we look at Kearns, which I disagree with on a number of levels, but I think that the standard that they applied to Mr. Kearns' claims when they actually were put before court, he established essentially a prima facie case of, I believe it was fraud under one of the specific Florida statutes. So he was able to at least show that the evidence said, okay, here's the different elements of fraud, and we have evidence to support all of that.
And how is that different from what he would have to allege at the motion to dismiss phase? I guess that's my quandary, is it doesn't seem to me, like, based on what you're saying, that his burden shifts at all over the course of litigation, whereas most of the time it would, right? We would expect a plaintiff at step one to have made an allegation but at the jury verdict phase to have established something.
Right. And I think that's because we're sort of case within a case on this one, whereas his actual elements of his whistleblower claim might be very basic in the complaint and then evolve and sort of fill out over the course of the litigation, whereas the underlying thing that he blew the whistle on, those allegations are going to basically stay the same throughout the course of the proceeding. In order to survive the motion to dismiss stage, he's going to need to assert, this is what I believe they did, this is what I believe was violated, and then we'll just put the evidence together. But I don't think that that's going to change substantially throughout the course of the proceedings, even as we get into the trial phase, whereas his actual prima facie evidence under the whistleblower claim, that is going to evolve and grow over time, if that answers your question.
I'm going to back up from this a little bit. What do you say that the district court got wrong?
The definition.
That's why we're here, right?
Yes.
What did the district court get wrong?
The definition of the word is, unfortunately. So the district court followed the Kearns opinion out of the second DCA, which follows a middle district case, the White versus Purdue Pharma. And they say that the use of the word is a mandatory, literal, he must show that there was an actual violation of a law, rule, or regulation in order to proceed with his whistleblower claim.
As opposed to the employee having a reasonable belief that the proposed action or the activity, policy, or practice would violate the law.
Correct. That it's the...
Okay, so it's all about whether... And this actual is a little confusing because it's very clear from the context, at least to me, that doesn't have to have actually been a violation of the law that occurred. If a proposed activity, policy, or practice that the employee refused to engage in didn't actually go forward because the employee refused to engage in it, then the question is whether what was proposed or instructed or directed or required by the employer would have been an actual violation of the law.
Right, and that's our position, is that when we look to sort of those future actions, and it's the barrel of toxic waste example, I think, that was used in the NELA amicus brief. If the employee refuses his supervisor's instruction to dump the toxic waste into the river and goes and informs somebody, hey, this will be a violation of law, and he gets fired immediately, if we look at just this very literal actual violation of law, there technically wasn't a violation.
Okay, how does that relate to this case?
Well, so if you restrict one, you restrict it all, is essentially how it relates to this case. So where we have
No. Tell me, I don't understand. Give me the facts of this case what happened?
So Mr. Gessner, over the course of his employment, and this is sort of a construction manufacturing environment, reported a number of safety issues, just for brevity's sake, that he believed were in violation of various OSHA standards and not necessarily specific violations of a written legislatively enacted law. And our position has always been that he had a good faith, objectively reasonable belief.
But all this is about whether good faith is good enough.
Well, I would say good faith alone is not good enough. We need to add the objectively reasonable standard. Okay. Otherwise, the employer does suffer from additional burdens that are not contemplated by that statute. So we would absolutely advocate that the reasonable belief needs to be there. Otherwise, we're all going to be in court all the time, which only benefits some of us.
Well, the first DCA and the second DCA take the position that the employee has to show that the employer actually violated the law.
Correct.
Then you got the fourth DCA basically saying that the employee had a good faith, reasonable belief that the employer violated the law.
Right.
But the statute, the text of the statute uses the word is.
Yes.
So I guess what it says is that the way it should be read is that the employer is violating the law. So how does that, what do you suggest?
So we take the position that the good faith, and I may just say the good faith standard, but objectively reasonable is part of that. And that comes from the fourth DCA followed the Luna opinion, which was another district court case, which relied on the way Title VII has been interpreted. And if we look at Title VII, it says that it shall be an unlawful employment practice for an employer to discriminate against any of his employees because he has opposed any practice made unlawful by this section. So it's that same sort of specific language. And the way Title VII has been interpreted for like 40 years is that that's not an actual violation and objective.
Well, but this text, I trip over the words of this text when you start talking about that, because it says which is in violation.
Right, and I agree with
and that seems to me to be pretty clear.
It does on its face, but if we look to, we have Title VII, and this is what White disagreed with, was that Title VII, it's a federal statute, that was federal law that was interpreted. However, if we look to the Florida Civil Rights Act, which is patterned after Title VII and interpreted in tandem with Title VII, it uses is. This is in 760-10 sub 7. It is an unlawful employment practice for an employer to discriminate against any person because that person has opposed any practice which is an unlawful employment practice under this section. So we have the same use of the word is, yet
okay,
we're
but
relying
you've got
on
a different statute, and you've got a rule of construction. Is that a statutory rule of construction?
That's the way it's been interpreted for.
Well, is that specified in the statute?
Within the text? No, it's not specified within the text.
Okay, so we've got something that's going on over there that's going on over there, but we've got this.
Correct.
And I'm just struggling with getting around this clear language based on these other things floating around out there. Because again, I'm not saying if this was unclear, that would be one thing, but it would be so easy for the legislature to say which the employee reasonably believed to be in violation of the law. I mean, that's what you want to be written in there.
That is what I'd like to be written there.
That is what you want to be written in there, but that would be so easy for the legislature to do. And elsewhere in this statute, like right above it there, they talk about an alleged violation of the law.
They do.
So it's clear that the legislative mind was thinking about things that are kind of in this realm, and when they talked about alleged. So I don't know. But to go be skeptical. I understand your argument. It is the kind of argument that has frequently been successful, but it concerns me that it really runs up against this text, which seems to be pretty clear to me.
Right, and that I agree with, and it's I was going to bring up the same point about the use of the word alleged in the section that immediately precedes it. But if you actually look at 448-1022 and what it protects those who provide information to any government agency, person, or entity conducting an investigation, hearing, or inquiry into an alleged violation. The alleged violation is not something that the employee brought forward. This is something that was discovered elsewhere. They are investigating it because it's still alleged. It's not yet an actual violation. We're still sussing out all of those facts, but we're offering the employee protection because they've been dragged into this investigation.
I think there is a tendency on what I've seen in the briefing on this case is, on the one hand, there is an attack on the importation of the word actual, and then on the other, there's an attack on the importation of objectively reasonable.
Right.
And rather than sort of rehash that debate, I think what you're hearing from at least two of us so far is let's just take the words as they are and leave Title VII and its tests behind and leave actual out of the picture. This is why I started with pleading standards. Mm-hmm. It seems to me that one way to engage with this is what do you have to prove and when? Because if we just don't try to adorn the statute at all, one way to make sense of the fact that we don't know at time zero when you're making the allegation, say, that there is a violation of law, because there hasn't been an adjudication yet. Right. And it would be nonsensical to say, well, it must be an adjudication. That would be an absurd result. But on the other hand, at the conclusion of the trial, at the conclusion of the process, you would have had to establish something. And it seems to me that that's one rational way to read the text as written, is to sort of ask what must you establish and when. And so that I'm wondering whether you can help us understand what you need to survive a motion to dismiss, a motion for summary judgment, and to prevail on the merits.
Right. Well, and that, to that extent, I do agree that the sort of end game sort of justifies what happens prior to that. Our problem is the difference, and I know we don't want to use actual and objectively reasonable, but what are we attempting to even show the jury that we objected to? And I bring up Title VII because it provides a pretty decent example. Like, let's say, for example, we have a hostile work environment claim. A derogatory term is used in the workplace. I immediately run to my supervisor and I tell them that's not yet a hostile work environment, but I'm supposed to report that in an effort to prevent this future harm. So we wind up with a similar issue here. If I go back to my toxic waste barrel situation, if we see that something is going to happen that could potentially violate the law, the idea behind these statutes that protect employees who do this protected reporting.
So then in this case, let's leave the hypotheticals aside. Okay. You have your client is saying some very inappropriate things and is having performance issues and, is in a tricky employment situation and also alleges an OSHA reg violation. Walk me through the analysis in our case about what needed to be established and when.
In our case, we would argue that he needs to, and he alleged in the complaint, and then obviously we dealt with this on summary judgment, that what he objected to, he had an objective belief that this was an actual, that this was a violation of law, that let's say, I believe there was an issue with fire in various small confined spaces, something along those lines that just from its face looks dangerous. There's fire, you want me to go in there, that seems like a bad idea. So he reports this to his supervisor. He has an objectively reasonable belief that this is a violation of safety standards and rules and regulations.
And you think, okay, so now he should be able to survive a motion to dismiss just on that?
Yes.
Okay, summary judgment.
Summary judgment. So now we get into this burden shifting analysis. He makes the same arguments that he reported these violations, or what he reasonably believed were violations of laws, rules, and regulations applying to the safety in the workplace. Now, this is where the protection for the employer comes in, because we've established our prima facie case. He makes the report, he is then fired. They're going to come in and say, okay, but he was a bad employee. He used a racially derogatory term. He did this, that, and the other. We wanted to fire him. That's valid. That's the legitimate, non-retaliatory reason. We then have to come back and prove that that's false. And that's where we get in summary judgment, which is one of the issues we have on summary judgment, is we have to establish that that was false and that retaliation was the actual reason that he was terminated. So once we get past that, then we get to present it all to the jury, who can then determine, was his belief that fire in a small confined space violated a safety regulation? Did he actually engage in that protected activity? So that would be the process in relatively simple terms. And I do believe I only have 3 minutes left, so if there's no other questions, I'm going to save the rest of that time for rebuttal.
May it please the court, Matthew Gutierrez on behalf of Respondent Gulf Power. Your Honors, the respondents have agreed to split their time, with 15 minutes going to Gulf Power and 5 minutes going to Southern Company. This appeal presents a single question of statutory interpretation. To establish a claim under Section 448.1023, must a plaintiff prove that he blew the whistle on an actual violation of a law, rule, or regulation, or is it sufficient that the plaintiff demonstrate he possessed a good faith, reasonable belief that a violation occurred?
And when you say actual violation, you do not mean a violation that had in fact occurred. You mean it would encompass that, but it would also encompass a course of action that would have been in violation of the law if it had occurred.
So an instruction to violate the law is an instruction to conduct activity in the future. And the purpose of the statute is to prevent illegality and to promote opposition to that. So if you in fact object to the illegal conduct and as a result it doesn't occur.
That's proposed.
Correct. The instruction is to do something in violation of the law, rule, or regulation. That is sufficient. But the fact that it doesn't occur is what the statute is trying to accomplish. It's trying to prevent it from occurring to begin with.
Because you object, and then you're protected for objecting to something that, if done, would be a violation of the law.
That is the definition of the protected activity. It's exactly what the statute is trying to accomplish.
But the way that you square that with the statute is to say that the instruction is in violation of the law. Because the statute says that there has to be an employment or a practice policy or something of the employer that is in violation of the law. And so if it were purely a matter of just prospectively doing something, that wouldn't be covered by the statute. But you're saying that under the facts where you've actually been instructed to do something, that in and of itself is as Tannenbaum says in his concurrence, that it's in a present state of illegality.
Correct. The instruction is to do something that is in violation of the law, and that is sufficient in our view. So, and there's been some discussion about adding the word actual to the text. We don't believe that the word actual is adding anything. It's part of the definition of is. So the text says that to qualify for protection, the the activity, policy, or practice must be such that it is in violation of the law, rule, or regulation. Is means the present indicative of be, which means to exist in actuality. The word actual comes from actuality. Is links the antecedent, which is the activity, policy, or practice, with the prepositional phrase in violation of law, rule, or regulation.
So I'll ask you the same question I asked your friend. What is it that what is it that a plaintiff has to prove to survive a motion to dismiss? If, for example, we're dealing with as we are here, an allegation of, as you've articulated this morning, I'm not hearing much disagreement with the other side. Mr. Gessner alleges a state of play, a state of facts that are in violation of OSHA regs, right?
We disagree, Your Honor.
All right, so help me understand the disagreement, because I think the most aggressive reading of your position requires almost, as I said earlier, a sort of unreasonable sort of conclusion, an adjudication even, that there has been some sort of violation of the law. So help me understand what you think a plaintiff has to prove at the motion to dismiss phase and at summary judgment if your reading of the statute prevails. How is it different than her reading of the statute?
So a couple things. On the OSHA violation, they're referring to the OSHA catch-all provision. What you won't find in their briefing is any argument that there was an actual violation of that standard. They have now abandoned that, and for good reason. In the trial court, the First District, in neither of those proceedings did they ever allege the 4 elements of the OSHA catch-all provision, 2 of which are conspicuously absent. The feasibility of mitigating the harm, there's no evidence of that whatsoever. They also have to establish that there is no other applicable OSHA regulation to the conduct in question, which in a power plant is going to be the case. So we disagree that they've alleged a state of play that there's an OSHA violation. With respect to whether there needs to be an adjudication that conduct is, illegal before the employee can object to it, of course not. But this is just like a wrongful death case that's premised on murder, and you have overlapping civil litigation and criminal litigation. It happens all the time. There are many high-profile examples of a criminal defendant having been found or acquitted of murder, but then being sued in the civil context and prevailing because the standards of proof are different. So whether or not a criminal prosecution or any other type of adjudication of illegality would have a preclusive effect in the civil case.
I lost you. What is it that Mr. Gessner has to establish to survive a motion to dismiss under your theory?
That the activity, policy, or practice is in violation of a law.
Would be a violation of the law if he actually did it?
If it's a forward-looking instruction, then he has to prove that the instruction itself was to do something that is in violation. If he's objecting to something that's already occurring, he has to be objecting to something that is in violation of a law, rule, or regulation.
So is it inevitable in these cases then that, so part of the litigation is going to involve how the objection was articulated to the employer, and then sort of the causal relationship between that and whatever the adverse employment action is. But then is there, and that's what the other side, I guess, in response to some of the questions kind of jumped to that about, is it really, is there some other reason for the employment decision? But is it inevitable that the part of what's being litigated is just sort of, it becomes like a little mini trial within a trial on whether it's the instruction or whether it's something that has in fact already occurred? does that violate whatever the alleged sort of law that's in play on the OSHA thing in this case? So in this case, so then as far as, so at the motion to dismiss stage, you'd have to just allege in your complaint something that, if true, would be a violation of the law. And then at the summary judgment stage, you would just be asking whether the record shows that essentially that, you know, that there isn't any disputed material fact on that issue. But it is, within this, it is kind of, it doesn't have to be adjudicated beforehand, but I mean, it is kind of being adjudicated within this proceeding, right?
A case within a case.
Right,
So,
and so obviously it doesn't have any binding effect if OSHA decided to go after the employer or whatever, but I mean, that is substantively on the table in these cases.
absolutely, yes.
I think that's a very significant, I want to make sure I understand that, because if it's to my mind, that's a very significant, I don't want to use the word concession, but so if, to play the Chief's hypothetical out, it's not a hypothetical, if OSHA ultimately established there was no violation in this case, after the fact, your case is fully litigated, and a year later, OSHA concludes there was no violation, you would still say that if the trial within a trial resulted in the conclusion that there was, you would conclude then that there was that Mr. Gessner had objected to an activity, policy, or practice of the employer which was at the time in violation of the law, rule, or regulation, even if you were ultimately decided to be off the hook by OSHA.
It's collateral estoppel. I mean, it's issue preclusion. If whether or not it has a preclusive effect, you have to go, and that's not been briefed, but you have to go through the mutuality of parties. Was it an adjudication on the merits? Was it the same exact issue? So it's just like any other context where you have overlapping issues being litigated in different cases. There's no difference. We see it as the same. OSHA may or may not find a violation before or after. You're going to have a situation that arises when you have two cases that deal with the same conduct between different parties.
But if OSHA finds a violation before it gets litigated in the employee's case, then the employer's in a world of hurt.
Correct. Absolutely.
But if it happens after the fact, after it's already been adjudicated favorably to the employer in the employee's case, then that's just, why wouldn't that be res judicata? I mean, that's over.
Yeah.
But the whole business about, you know, am I being instructed to do something, or am I seeing the possibility of something that, if it were actually carried out, would be illegal? Like, that's not really what this argument now is about. This argument is about, if I'm complaining about something, even in a good faith, reasonable belief that it is illegal or would be illegal if I did it, if I'm wrong about that, if the little mini trial within a trial says, look, yeah, they really sincerely believed and objectively thought this was illegal, but it's not, then that's, the person would lose. Under your view of the law, they would lose, right? And that's what this is about.
Right.
It's not about like whether it's a prospective proposed thing that would clearly be a violation versus an actually consummated violation.
And there's nothing wrong with that outcome. I mean, the starting point at common law was that we're an at-will employment state. The legislature created a protection, and it was free to create a protection as broadly or as narrowly as it saw fit. And it actually picked and chose throughout the statute when to provide broader protection for alleged violations, as in subsection 2, and suspected violations, as in the Public Sector Whistleblower Act. In our provision, which is subsection 3, it says is in violation, and we have to apply the text as plainly worded. And they have now said, and my colleague on the other side says, she said it's clear on its face with respect to the words, and that's this court's exercise, is to assess what is the common and ordinary meaning of the words in the statute, and then apply that.
Is the difference between your arguments from a pleading standpoint, that the reasonable belief kind of pleading is, I believed this was in violation of OSHA, versus what you're saying from a pleading standpoint is the facts, if true, need to be in violation of OSHA. So from a pleading standpoint, I don't really understand the trial and a trial standpoint. It's just from a legal basis, could this be a violation of OSHA in the sense that if it's the catch-all, then there's a feasibility requirement, that sort of thing. Is that what you're saying from a pleading standpoint, or is the pleading requirement more?
Well, the pleading would just have to allege facts that, if true, violated the law. So in the case of OSHA, they would have to go through all the elements and allege facts that satisfy all 4 elements. We don't even know what the elements are. I do, but it's not in the briefing because they're not asserting an actual violation anymore, and they barely did so below. What they did was they had a shotgun style. All these bad things happened. There was fire, there was hydrogen, there's coal in this coal plant. I think that that's flammable, so therefore all that I reasonably believe violated OSHA, but maybe it also actually violated OSHA. And there was one line in their briefing in the first district that said, oh yeah, by the way, all that stuff is a violation, after saying that he reasonably believed it was a violation. So what we have in this case is, in our view, somebody who is identifying through common sense. They're working in a dangerous environment in the sense that there are flammable things in a power plant, but that's part of the nature of his job. He's there to fix things. He's a mechanic. He's working where there's coal, there's hydrogen, there's a permissible leak rate of hydrogen, but he's identifying all these things and saying, I think that that's dangerous and therefore I should be protected. The law requires an actual violation. So I also want to emphasize that the idea that a reasonable good faith belief is sufficient has no textual basis whatsoever, and we've not seen any opposition to that in the briefing. And as I've noted in my briefing, the reasonable good faith belief standard comes from the Sias case in the Ninth Circuit, which basically acted, in the Ninth Circuit case, the court basically acted like a legislature and said, we think it's unfair for employees to be held to this actual violation standard, so we're going to create an exception for public policy, and that's not the way that Florida courts interpret statutes.
Do you think there's any advantage at all in the sort of continued use of any federal test standard for the statute?
I'm sorry, can you say again?
So do you think there's any advantage at all or any point in continuing to use any sort of the federal test or standard or 3-part pronged proceedings that the lower courts have used in interpreting this particular statute?
It's the typical burden shifting framework that is applied in discrimination cases. It's also not required by the text, but Florida courts have always used it. And that's actually where the problem arose.
Should they continue to do that?
It wouldn't affect this case, but whether or not they should is, I guess, not part of this case. I'm not really sure it matters for this case. But the burden shifting framework is what Florida courts have incorporated, but they have not incorporated all the substantive law from Title VII, which is where the Luna court sort of committed the original sin of conflating the concept that Florida courts have adopted the burden shifting framework for Title VII with the incorrect notion that they've also incorporated all of the substantive law and precedents bearing on the substantive requirements of Title VII, conflated those two concepts, and then just passively, almost without any analysis of the text whatsoever, saying, oh, because we applied the Title VII framework, we're going to apply this Title VII reasonable good faith belief standard, and that was what led us here today. The 4th District followed suit and did the same thing. So unless the court has any other questions, I've gone into my colleague's time, and we asked the court to reject the 4th District's atextual good faith reasonable belief standard and accept the 1st, 2nd, and 5th District's actual violation standard. Thank you.
May it please the court, Russell Van Sickle on behalf of Southern Company. Our interests are aligned with Gulf Power Company, and we really do not have a different argument from Gulf Power Company, so if there are no questions, we will rest on our briefing.
Thanks.
All right, my friend across the aisle used the phrase common sense, which I think is something that we need to actually look at in this context. What's the practical purpose? Why did the legislature implement the whistleblower statute in the first place? And it's to encourage reporting of workplace wrongdoing without fear of reprisal. And if we limit what an employee is protected over when they report, we basically undermine what the statute was designed to do.
Is that they chose, whether it was wise or not, they chose this to define the wrongdoing that they're protecting you from complaining about in a certain way. It's like you're just running up against a linguistic wall. You know what I'm saying? I mean, I'm not saying that a perfectly rational legislator wouldn't want to, give people a little breathing room, but they wrote it the way they did.
Right, and they also wrote the Florida Civil Rights Act with the same restrictive language, but it's not interpreted that way. It's interpreted in such a way that we preserve as much of the right of access to the court system as possible for the aggrieved employee. It also uses the phrase is and makes it clear that it should be an actual violation, but the standard that's applied comes from Title VII. That's why we keep talking about Title VII, and it applies the good faith, objectively reasonable belief. If we were to put this actual violation burden on the employee, we're essentially trying to turn them into mini lawyers. If I see that something is about to go down that could potentially violate the law or be incredibly unsafe or dangerous, do I walk away, find a computer, figure out what law might apply, confirm that I'm correct, and then take this back to my employer? Has the building already burned down by the time that's happened? Has a wrong that could have been righted occurred because I was too scared that if I don't present this actual violation of law, that I would be fired and I would have no recourse?
Why isn't that an argument better directed facing that direction? Why isn't that a legislative argument?
And respectfully, it could and probably should be. It just hasn't been. Why? That I'm not sure. I think because over the years that we have just sort of fallen into a position where we have this good faith, reasonable belief versus the actual, and the trial courts are just applying whatever seems to work in that situation. And this really is the first time that we've had to sort out the issue, and we're doing it here, although there would, certainly make my life a little bit easier. But our position is that although the first, second, and fifths are now in harmony and following this White opinion, that they've taken the wrong position, and it's far too restrictive to preserve an employee's right to access the court and redress any kind of wrong that they've had. And we would ask that this court adopt the objectively reasonable standard that's set forth in all of the other discrimination laws that apply to employees, and reverse the First District's opinion in this case. Thank you.
Thank you.